well, but good morning to all of you. You have entered the land of Sonrisers. We are so glad to have you here with us today. It's been awesome to watch how our attendees have grown. It multiplies every week. It's so awesome that we're now able to be online and do all of this. It's such a blessing. And Tom, you showing us your chest?
And I was looking at three deers outside of the window.
Oh, that's
eating.
so cool.
Yeah.
If Alex were here, he'd run and get his gun. But that's awesome. So we're going to start this morning off with Tom doing our devotional. How are you, Tom?
I am doing well. Blessings and greetings to everyone on Memorial Day weekend. If this was a regular week, we probably at Sonriser would not be meeting because Monday being a holiday, but because we're on Zoom, we can be anywhere and still participate. So good morning, guys. The verse I want to use this morning is one I looked at and pondered over, and it's Proverbs, the 23rd chapter, the 7th verse. And the writer writes, "For as he thinketh in his heart, so is he." As he thinketh in his heart, so is he. Now notice what the author didn't say. He didn't say that this person is because of his birth, where he was born, what zip code, what country. He didn't say because of this person's family, who he was born, the family he was born into, how they are known, or where they are in society. He didn't mention anything about country, whether he was born in America or in Africa or Haiti or Brazil. It didn't mention that. He didn't mention education, whether or not the person had a Harvard degree or whether or not he graduated from the School of Hard Knocks. He didn't mention the person's race, where he was from, or family or race or anything else like that. The author didn't mention anything about socioeconomics, whether or not this person was born with a silver spoon in his mouth or her mouth, or whether or not they were born foraging for anywhere that they could eat. But the verse says, "As a man thinketh in his heart, so is he." I was reading something from Ralph Emerson, and this is what he said. He says, "Sow a thought, reap an action. Sow an action, reap a habit. Sow a habit, reap a character. Sow a character, reap a destiny." Habit is the intersection of knowledge, what to do, skill, how to do, and a desire, a want to do. People can't live with change if they don't possess a chainless core inside of them. Until a person can honestly say, "I am what I am today because of the choices I made yesterday," that person cannot say, "I choose otherwise." I mean, we are what we are because of choices and decisions that we make. It is one thing to make a mistake, and quite another thing not to admit it. People will forgive mistakes because mistakes are usually of the mind, mistake of judgment, but people don't easily forgive the mistake of the heart, the ill intent, the bad motives, the prideful justifying, the cover-up of the first mistake. Admission of ignorance is often the first step in our education. Our behavior is a function of our decisions, not our conditions. I just want you to hear that again. Our behavior is a function of our decision, not our conditions. we pretty much believe that we behave because of our condition. But in essence, we behave because of our decisions. The ability to subordinate an impulse to a value is the essence of the proactive person. When we see something or ready to say something, but yet if we can subordinate that and realize that something better is in store for us, can make us tremendously successful. How you treat one reveals how you regard the many, because everyone is ultimately a one. So when we see our actions and how we relate to a person, and we may do that and justify ourselves because we say this person is this way or that way or some other way, but it normally shows that how we treat that person in our essence is how we will go out and treat someone else. There is no better way to inform and expand your mind on a regular basis than to get into the habit really of reading God's word. I mean, because our infinite self, we cannot expand ourselves greater than we would be with the word of God. This is something from Stephen Covey, The 7 Habits of Highly Effective People. And this is what he says. Habit 1, be proactive. Habit 2, begin with the end in mind. See where we want to be. See where we want to go. Start off with that premise and then let our life and our actions work toward that. Put things first. Think win-win. Number 5, seek first to understand, then to be understood. Habit 6, synergize. Habit 7, sharpen the saw. You know, in Luke 6:45, the writer writes, the good person out of the good treasures of the heart produce good, and the evil person out of the evil treasure produce evil, for it is out of the abundance of the heart that the mouth speaketh. Are we judged by what we say and how we speak, and then said, oh, I'm sorry about that. Oh, that was just a mishap. That I don't know why I said that. But the scripture said, out of the abundance of our hearts, man speaketh. So the process I want to say to us this morning is to encourage us to look inwardly, you know, clean our hearts, where our thoughts and our desires for life and for others is pure, that we want the best for those that we come in contact with, that we will be one, because Jesus said it's not the things that go into a man that defiled him. He said those things that go in, they go through our body and it's waste. But he said the things that come out of man is from his heart. He said that's where murder and sin and all the other things come from, the inward man that's there. So now we this morning should have a better handle on how to control that, because as we think, that's how we are. So let's plan our thinking. Let's prepare our thinking. Let's be able to feed our heart with good things, so that those will be the things, as Mary was talking about her garden, how it needs water, how it needs that element for it to grow and to come to a point where it becomes fruitful. That's the same thing we are with our hearts. How do we feed our inner heart? How do we allow it to grow and become fruitful? That's the question that I ask and want to leave with you this morning. Let's pray. Gracious, eternal God, Father in heaven, Father, we thank you for this day. Father, we thank you for your word, how it's, Father, it's like an x-ray, like an MRI, like a CAT scan that can see us, Father, completely through. Man look at on the outward appearance, but Father, you look at the heart. And we just ask you this morning to cleanse, and purify our hearts. Father, give us that ability to be able to think good things, to plan good things, to plant good seeds and let them harvest in our lives. And let our light, Father, be a blessing to those that we come in contact with. Let us, Father, put ourselves in a point that when we meet someone, we talk with someone, that they are better off after we leave than they were before we came. Let us always be able to share good news to those we come in contact with. And Father, foremost, we lift you up in all the great things that you have done for us. And we do that in the name of Jesus. Amen.
Amen. Thank you so much, Tom. You know, you mentioned a book that's been around forever, and it's always a good book to go back to, The 7 Habits of Successful People. Is that what it's called? The 7 Habits of Highly Successful People.
Right.
Stephen Covey. That book, it's what, 20 years it's been out, maybe, or
At
longer,
least.
longer than that.
Yeah.
That is a great book for everyone to go back to and read and kind of just keep around. That's one that you can always fall back on, you know, because habits it changes everything. Your habits change everything, and habits are hard to form. And once you form them, they're really hard to break. So that's a good thing for us to keep in mind, you know, when we're forming the good ones anyway. But, you know, the other book that has habits in it that I love is The Rockefeller Habits. But, you know, they both kind of go back to the same thing, is putting yourself into a habit to do the same thing, focus on what's important and take that step over and over again. That's awesome. I love it. Is Dot looking for that book for you? Is that what you have?
Yes, ma'am.
I see you back there telling him it's back there. It's back there. Look, she didn't find it either. It's buried up under something, Dot. I'm sure. Thank you, Tom. It's always awesome to hear from you. So, Mary, congratulations. We have more people on our meeting than we've ever had right now.
Oh gosh, pressure's on. Make me nervous about it. Thanks.
Folks, I have to tell you, Mary is a very, very dear friend of mine. And it's funny, the first time we ever met, we met at a Freedom Founders conference. Do you remember that? In a restaurant. And we had both heard each other's names because we kind of hung around in the same circles, but we had not ever met. And when we met, we instantly connected. We were instant sisters. She's I just love her. I love her, and she knows I love her. I tell her that all the time.
Love you too.
And she's like the smartest chick that I know. That's how I introduce Mary. And I see everybody who knows her is nodding their heads. Yes, she's the smartest chick I know. She's got this great story about lightning lips that I'm going to ask her to share that with you, because I did put that in our reminder today. And look, there's even more people coming in, 3 more from when we started talking. So, and you know, Mary said, well, what topic do you want to talk about? And I'm like, Mary, you can talk about anything in the whole wide world and be an absolute expert on it. So one of the things I know that we hit on a lot is trusts. You know, whether they're good. We even talked last week about, because I'm buying properties with my partner, Darren, in a trust right now. And you said you don't buy properties in trust. So I do want you to bring that up and talk about that, but there's different kinds of trust and what they mean and all of that kind of stuff. You know, you're also like, you've been doing Airbnb before Airbnb was born. And if you get a chance to talk about that, you know, I'd love for you to throw that in too. So now I'll shut up and I'll let you go. Ladies and gentlemen, Mary Hart.
Hello,
Go.
everyone. Nice to see you on Zoom. This is a new thing for me to do these conferences on Zoom. It's very cool that we can do this. Thanks, Wendy, for asking me to talk. You want the lightning lip story first, or you want to jump right into trust? Some of you, I know Ginger and Ken have heard this, and several other people, but when I was a baby lawyer back in 1991, I had my first telephonic hearing with a bankruptcy court. I was living in Alaska, in Juneau, Alaska, and the court was in Ketchikan. And when I talk fast anyway, but when I get passionate about something, I talk really fast. And anyway, I was presenting my case for my client, and the judge on the record said, "Whoa there, lightning lips. If you think my puny brain can possibly keep up with the speed of your mouth, you're crazy." Anyway, that is on the record in Ketchikan somewhere in the court, and I've never lived that moniker down somehow. So anyway, so if I talk too fast, just stop me and I'll slow down. It happens. Well, trust, trust is a big, big, big topic because there are many, many, many types of trust for many types of purposes. And I don't know how familiar this group is with trust or not. So I'm going to go start with something fairly basic, and then we'll move into land trust specifically. But, I find there's, let me say, I've been an estate planning lawyer for 30 years. I'm retired now, but I'm coming into my 30th year. So I've done a lot of trusts, thousands of trusts over my lifetime. And one common thing I find is that people don't even understand what a trust is. Like, is it a box somewhere? What is a trust? And so really, real estate people, I tell them it's a very easy to understand a trust because a trust is just a contract. You guys know contracts, you're real estate people. A trust is just a contract between the person who sets up the trust, the grantor, the trustor, the settlor, they all mean the same thing, and the trustee, right? And it's a contract set up between those two parties for the benefit of the beneficiary, which is we call the third party beneficiary. So that's all it is a contract. And the terms of that contract are whatever you write in the trust document. If you think of the trust document like a contract, it's what do you want to write in there? Now, every state has trust laws, and there's some things you can't put in a trust because of against public policy or whatever. But basically, it's very, very broad, and you can put whatever you want into it. And although there can be oral trusts, they're very rare, and most of the time it requires a written document to create the trust. That document is signed by the grantor and the trustee. And now once you have this trust, how do you make it govern something? Well, you have to transfer assets into it for the trust to govern those assets. So I've seen thousands of people who paid big bucks to set up these great estate planning trusts, right? And they never put anything in it. So they've got this beautiful $4,000 trust document, and it governs absolutely nothing if they don't put anything into it, right? So just keep in mind that to set these up, you have to have a written document, and you need to transfer some assets into it in order for it to govern something. Now, there are big categories of trusts. You can have an inter vivos trust. That's one you set up during life. It becomes effective during your life. Or you can have a testamentary trust, which takes effect upon your death, is created through your last will and testament. And we could go for days on trust, so I can't go into all the details, but there are many types of trust. Those are the two big categories, inter vivos or at death. The other big category is it revocable or irrevocable, right? And what's your purpose of the trust? So trust can do everything from avoid probate, provide some creditor protection, and the amount of creditor protection depends on the type of trust you use. And we're going to get into that more with the land trust. Trust can be used for tax planning, for disability planning, for dealing with different interests when you have second or third or fourth marriages and children from prior marriages. Can be asset management for minors. There are many, many reasons to set up a trust. So you have to look at what your purpose is and your goal to decide which trust is appropriate. Some of the most common trusts we see, of course, are you've got your revocable living trust, quote, living trust, that's the term of art, for your estate planning purposes. You've got the land trust and personal property trust we see a lot in the real estate investment world. You have true creditor protection trust, like a domestic asset protection trust or an offshore asset protection trust. You've got things like a life insurance trust to keep the proceeds of life insurance from being taxable in your state and things like that. So you have to know what your purpose is. So if I were doing an estate planning trust, my main purpose is probably to avoid probate, right? To make the administration of my estate easier, cheaper, and quicker. And so we're not going to talk about that type of trust, but that's just an example. That's if I'm going to set that up, which I have one for my estate, because I don't want to have my family go through probate after my death, because it can be a real pain in the rear end, right? So if I'm looking at an irrevocable trust, and I want to just say this, most of the times the main purpose of an irrevocable trust, one you cannot change or get rid of once you set it up, that main purpose could be probate avoidance, but it's usually some sort of asset protection. You know, and the reason, let me just say this one thing, because I think this is helps keep in mind what type of trust. Keep in mind that your creditors, if you have the ability to get to an asset, so do your creditors. All right. So if I have a revocable trust that I can pull the assets out of and I have control over it, then if somebody gets a judgment against me, my creditors have that same control. They basically reach that asset if I can control it. So the reason an irrevocable trust is what we use for true creditor protection is because I have relinquished my control over that trust. I'm the grantor, maybe I set it up, but I'm not the trustee. And except in rare circumstances, I'm not even the beneficiary. I have given that trust away, say like I've set it up for my children to inherit in the future, but my brother may be the trustee or somebody, you know, I can't go in and retrieve those assets anytime I want to. So because I've relinquished control, it's not taxable in my estate and my creditors can't get it. It's like I've gifted it away to a third party that happens to be a trust. I no longer own that asset. Does that make sense?
Mm-hmm.
Anyway, so that's what irrevocable trusts are. Now, when we set up a trust, I mentioned earlier, the first thing you have to do is decide what type of trust you want. And we're going to talk specifically about land trusts and personal property trusts in a minute. You have to create the trust document, the written document. You have to have it signed by the grantor and the trustee. You have to transfer assets into it, or have it set up so that maybe those assets pass through your will directly into that trust on death, if it's one you don't want to take effect until you die. Somebody has to manage those assets and follow the terms of the trust. And then once we've set it up, let me get through them. I'm looking at some slides behind me if you're wondering what I'm doing, looking away from the computer. I've got a PowerPoint that I'm trying to follow so I don't forget anything. Anyway, let's talk about land trust. If I
you know, Mary, if you want to share that screen, you can. If you want
to. It's on
to.
a different computer. It's
okay, gotcha. Go ahead. Sorry.
Yeah. Anyway, and I'm happy to send this PowerPoint if you guys don't share it around. You know, I can. It's an old one from 2016. It was, you remember it, Wendy? It was from Jim Ingersoll's boot camp, and it was the Pepto-Bismol slides with all the paint, because I'm not a computer person. So I was trying to do this PowerPoint. It looks like I just threw up Pepto-Bismol all over these slides. Anyway. So, but I'm happy to share the information if you want it. Anyway, so let's talk specifically about land trust, and I'm also going to talk about personal property trust, because to me, they're basically the exact same trust. In fact, I use the same trust document, whether it's for real property or personal property. So let's just consider, we'll call them land trust, but it's also for personal property. So what is a land trust? Well, obviously it's a trust, just a contract between the grantor and the trustee. It is revocable. So what does that tell you? Right there, that tells you that it is not a true creditor protection trust, right? One of the biggest fallacies I hear people say is, my assets are completely protected because all my real estate is in a land trust. Ding, 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 wrong answer. That is not correct, because it's revocable. Remember, if you can revoke it and take the stuff out, your creditors can have access to what's in there. So we set up this land trust. We title, let's take a rental home. We title our rental home in the name of the land trust. So now we know that that house is governed by the terms of the trust because it is owned by the trust. Literally, the deed would read, you know, if it's my land trust and I name you Wendy as my trustee, the deed would read Wendy Sweet as trustee of the 123 Main Street Land Trust, or her successor, right? So now that trust now owns it because I've put it in your name as the trustee of that trust. Okay, and by the way, when we deed property to trusts, you do not just deed it to the 123 Main Street Trust, because a trust is not, it's not the type of entity in most states that can own property. The trustee has to own it. for the trust. That's just a little technical thing. Many states now, however, have created statutes that correct people's mistakes when they just deed it directly into the trust and not into the trustee's name. So not all is lost in many states if you have done it wrong, but for the future, deed it in the name of the trustee, okay? And what that means, by the way, people talk about these land trusts are great for anonymity. But then I see a bunch of people name themselves as the trustee of their land trust. So what happens when they deed it to themselves? My land trust, Mary Hart is trustee of the 123 Main Street Trust. Well, I just lost my anonymity, didn't I? Right? Because
Mary,
my
what
name's now in
happens?
the deed, in the public record.
What happens if you deed it in the name of the trustee and you change that trustee? What happens to the deed?
Yeah, so that's why I said to Wendy Sweet, blah blah blah, or her successor.
Gotcha.
Nothing happens.
Gotcha.
So sometimes what happens, let's say I wanted to be the trustee down the line, but I still didn't want my name on the public record. I could name you as the trustee, right? Name myself in this private trust document as the alternate trustee, right? Put the deed on the public record so your name shows up, and then down the line you resign and I kick in as the alternate trustee. That is possible. That is possible. Now I will say, if somehow it does go to court, if you're the grantor and the trustee and the beneficiary, you're more likely that a court is going to set that aside and say there's absolutely no creditor protection because it's obviously just a ruse. There's no other third party involved.
Right.
So my feeling is you should name, somebody else as a trustee and pay them for their work. Make it a legitimate transaction. Doesn't have to be huge pay, $100 a year, $500 a year. I don't know, what's reasonable. But I think about, well, what's a judge going to look at? Judge is going to look at, well, how would a big corporation do this? Is this just your alter ego, this trust? In which case a judge will probably set it aside anyway, if they can get to it. But let's go back to sort of the basics. So you've got this land trust is revocable. You conveyed the real property to the trustee. Whoever the beneficiary is, and we're going to talk about that more in a minute, that beneficiary basically reserves the right or has the right to control and direct the trustee. Okay, this is how it's different than a revocable living trust for estate planning purposes. Because in a revocable living trust, the beneficiary is just the beneficiary. They don't do anything. They're just very passive. And the trustee is usually the person who set up the trust. Now, in my revocable living trust, I am all three roles. I'm the person who set it up, I'm the trustee, I'm the beneficiary. But it's not a creditor protection trust. It's to avoid probate and to make administration easier for my kids. So I don't care about the creditor protection with my living trust, right? But with a land trust, you have the person who sets it up. Let's say, use that example. I'm the person who sets it up. Wendy, you're my trustee. Well, who's the beneficiary? And this is key. Do not name your, yeah. Daryl, is that your name?
Darren, but I call him Daryl.
I see D Brocklebank or something. I don't know your first name. Anyway, so some third party's the beneficiary. Well, I see a lot of people name themselves individually as the beneficiary. Absolutely wrong thing to do. The reason being that if you're the beneficiary, you're less protected. You run through a stop sign, kill somebody, get sued, get a judgment against you, it now attaches to you and you're the individual beneficiary of that trust, they're going to be able to break into the trust. So if you set up a land trust or a personal property trust, never ever name an individual as a beneficiary. Either name an LLC as a beneficiary, which puts a line of state mandated creditor protection there if it's done properly, or name another trust as the beneficiary. Depends on how paranoid you are and how many layers of protection and anonymity do you want. But for instance, maybe I set up a land trust. Land trust owns my rental home. Wendy's the trustee. The beneficiary of that land trust is my personal property trust. Why do I do that? That way, if somehow my trust does get busted open and gets shown in a court of law, what do they find out? The beneficiary is a personal property trust. That's not on the public record. Nobody has access to that document. They don't know that my LLC is then the beneficiary of that personal property trust, right? So how many layers does a plaintiff have to bust through to even find out that you're behind the deal? All right, so how many layers?
Do that chain again. Do that chain again from the
So
land
chain,
trust.
and that's a later slide, but we'll jump into it now. That chain would look like this. I find a rental property that I want to buy. I set up a land trust, call it 123 Main Street Trust, whatever you want to call it. I name Wendy as my trustee. Wendy goes out and buys that property in the name of my trust. She's the one in charge as the trustee, legally signing. So she'll sign and buy that house. That house is now titled in the name of my land trust. My land trust document names my personal property trust or another land trust, but usually it's a personal property trust, as its beneficiary. So now who controls Wendy as the trustee? The beneficiary or the trustee of the personal property trust directs the trustee of the land trust, right? So I go house to land trust to personal property trust. Now my personal property trust, who's the beneficiary of that? My LLC. So I'm putting that mandated creditor protection in right there, that state mandated line. Who owns the LLC? I do. So ultimately I control everything, but it goes through 4 layers. I'm the manager of my LLC, which controls the trustee of my personal property trust, because the LLC is the beneficiary of the personal property trust. The personal property trust controls the trustee of the land trust because it's the beneficiary of the land trust, and the land trust owns the real property. Does that make sense?
Yeah.
So somebody goes to court, all they have is Wendy's name as the trustee on the deed, right? So they try to, they can't even, the trust itself is not a public document. So first of all, how do they even know whether it's worth paying all those attorney's fees to sue the trust as the owner of the rental house? They don't. So maybe they're doing a fishing expedition and the only name they have is Wendy Sweet. So they're going to go look up Wendy Sweet. Well, it doesn't really matter what her assets are because she's just the trustee. She doesn't have any personal liability for this land trust, right? So they will have no idea who the beneficiary of the land trust is to know whether or not that beneficiary is a big fish with deep pockets. So first they got to find a lawyer who understands land trusts. None of them do. John hired Jeff Watson, me, and maybe a couple others, but that's about it that I've been able to find. So most lawyers will never admit, other than me, because I will admit I don't know anything, but most lawyers will not admit they don't know what the hell a land trust is. Excuse my language there, but it's true. So they don't want to admit they can't tell you what it is, so they'll just tell you it's not possible to sue one, right? But let's say you find a lawyer who will sue a land trust. Well, the lawyer, if it's contingent fee, they got to know that there's a deep pocket or they're not going to give you a contingent fee. So they're going to charge you $400 an hour to go through litigation. And how many hours of sort of searching to find any information will it take? Well, they file a lawsuit thinking, well, there's got to be a deep pocket somewhere. It's a pretty little rental house, right? They ask the court to make the trustee disclose the contents of the trust document. Guess what? The trust document has a provision in it that says the trustee is prohibited from disclosing the terms of the trust document or the beneficiary of the trust document. So what does that mean? I'll give you a real example from a friend of ours, Wendy. You may know this, but I'm not going to say names on this. But anyway, this guy was a trustee of a friend's land trust. They're both friends. And the land trust got sued. The trustee goes into court, and the plaintiff's lawyer asked the judge to direct the trustee to disclose the contents of the trust document and the name of the beneficiary. So the judge said, well, sure, yeah, you need to do that, basically the trustee. And the trustee said, well, Your Honor, the trust document prohibits me from doing that. So if I do that, I'm going to be in breach of my fiduciary duty and liable for all actual and potential damages. But if you'd like to indemnify me from all future damages that I may incur by breaching my fiduciary duty, I'll be happy to turn it over. The judge said, never mind, move on, right? Because what judge, a judge cannot order a trustee to breach their fiduciary duty. That they usually won't anyway, right? So maybe the judge would say, all right, well, let's go back to my chambers, produce the trust document for me to prove to me that you're not allowed to show that trust document or the name of the beneficiary. But once that happens, the judge has to say, okay, can't get it, right? That's legit. That happens. So that's the beauty of a land trust is it has absolutely no actual creditor protection. You know, somebody sues the land trust and gets a judgment against it, they can go get that rental house that's in there. It's not protected. It's not like an LLC, you know, that has a certain type of judgment where they can't take the property. They can take the property. The beauty of a land trust is anonymity, smoke screens, you know, in terms of asset protection, making it difficult for plaintiffs' lawyers to figure it out. And, you know, plaintiffs' lawyers like low-hanging fruit. So they're going to look for an easier target. right? If somebody's out there just suing to try to reap a judgment and that you haven't really done anything wrong, they're probably going to move on when they see a land trust, because it's paying the rear end to deal with. Other benefits of a land trust, though, are that, you know, unlike the estate planning trust, the beneficiary, we talked about, maintains the right to direct the trustee. So the beneficiary stays in control. So I would still be in control even if Wendy were my trustee. I like that when I could say, make it so, number one, and you'd have to do it, right?
And I say, yes, ma'am, how high? You've got we've got a question from Tim Maloney. I think you even know him.
I do know Tim.
It says, would 123 Main Street go through probate when your LLC is the beneficiary of your personal property trust, which is the beneficiary of your land trust?
Okay, so good question. The land trust would not go through probate. That trust interest would pass automatically to the personal property trust as the beneficiary. The personal property trust would not pass through probate. It would pass directly to the beneficiary, which is the LLC. Now, will the LLC go through probate? Maybe, but if you do it like I do it, you have set up a revocable living trust for estate planning purposes, and that trust is the member of your LLC. It owns your LLC. So the revocable living trust for estate planning owns any asset that doesn't have its own beneficiary, and that makes it a void probate. Does that make sense?
Mm-hmm.
So if I have the way mine is set up right now, I have a revocable living trust. My revocable living trust owns my LLCs and owns, you know, my house, my whatever, anything that's not owned in an LLC, bank accounts, you know, things like that, I'm going to try to name in my living trust. So those all avoid probate. So when I die, my revocable living trust would say, give my LLC interest to my kids, for instance, or to Frank. So it avoids probate because my revocable living trust says it does. Now, what does that LLC own? It owns the personal property trust, which basically owns the land trust, which owns the rental home. So the rental home just passes through the succession of trusts to get to the ultimate beneficiaries of my estate plan without any probate. Does that make sense? The land trust passes automatically to the personal property trust. That passes automatically to the LLC, which passes to my beneficiaries under my estate planning trust.
Which is the big deal to begin with, because then they're not paying all the taxes, right?
No, it has nothing to do with taxes. No, a revocable living trust does not avoid taxes any more than a will. You can set up any type of trust to take advantage of estate planning tax credits, like the gift tax exclusion, the estate tax exclusion, things like that. But we're using the same, say, estate tax planning in a revocable living trust that we would in a will. So a lot of people think I have to use a revocable living trust to avoid estate taxes. No, you can do the same types of things in a will. Yeah, you can do that either way. So we can use them for tax planning, but it's not necessary for tax planning. It's just tax planning while avoiding probate. So we're avoiding probate fees.
That's right. Okay.
And none of these are avoiding income taxes, right?
So that you're still going to be, whoever the beneficiary is upon your death, they're going to have to pay like an inheritance type tax? Question mark.
So maybe it depends. Classic lawyer answer, right? It depends.
Yeah.
So there are the estate tax structure. There are federal estate tax laws, rules, and there are state estate tax or inheritance tax rules. Okay, let's talk about the federal, because most states piggyback on the federal. This is a big conversation, but let me just break it down really simply. So let's just assume we're looking at a federal estate tax. What happens with an estate tax is when a person dies, any asset they have control over. Remember, we talked about revocable versus irrevocable trust.
Mm-hmm.
If I've already given my asset away before death to an irrevocable trust, it is not owned by me when I die, so it is not in my list of assets for estate tax purposes. But if I have a revocable trust, whether that's a revocable living trust for estate planning, a land trust, a personal property trust, anything that I can control or have, take the assets out, that is included in my list of assets to determine how much net worth I had when I died. So all my assets are added up, all the debt is subtracted off, and I have a net estate value, right? That is all initially subject to tax, but then there are tax credits or deductions that determine whether I actually pay a tax. So for instance, let's say that I had $20 million. I don't, by the way, but it sounds great. Let's just say I did. A big example. Drats. So let's say, and I'm picking a really large number because you'll see why in a minute. Let's say I had $20 million. I was a really successful farmer. Not. But anyway, if I leave all of that $20 million to Frank, it's all passes free of estate taxes because there's an unlimited marital deduction. If I am married to a U.S. citizen, I could leave $20 billion to him and there would be no estate taxes on my death. Now, when he died, unless he was remarried and left it to another spouse, there may be estate taxes, right? Let's say that I left it, let's say I was not married and I left it directly to my kids. Currently, every person has an slightly over $11 million amount that they can pass free of estate taxes under an estate tax credit. Okay, so basically it's taxable, but the government pays the taxes on the first 11.2 or 3 million. I can't remember what it is right now. So if I had 20 million and I left that to my kids, they don't get the marital deduction. I'm not married to them, right? But the first 11.2 million comes off the top tax free. The rest is subject to taxes unless I leave it, say, to a charity. All right. So whether or not somebody has to pay taxes depends completely on the estate tax structure, how things are set up, you know, what the estate tax laws are in effect at the time, what your net worth is, blah, blah, blah. So for instance, when I talked about tax planning trust, we can do the same thing through a will or through a revocable living trust. If I want to say my goal is absolutely to have no taxes whatsoever, and let's say I am married with my 3 kids, I could say, all right, whatever amount I can pass free of taxes to anybody, the 11.2 million, I'm going to give that to my kids because these are kids from a prior marriage. So let's split the interest. So they're going to get 11.2 million split between the 3 kids. That goes tax free because I have tax credit that says I can pass 11 point something million free of estate taxes. Well, that leaves another almost 9 million of my 20 million left, right? I can leave that to Frank completely tax-free under the marital deduction. So when I die, I actually got $20 million out of my estate tax-free. Now, let's say I wasn't married, so I don't have that marital deduction. I know I can leave the 11.2 million to my kids free of estate taxes, but that still leaves $9 million. And the top tax bracket's 40% or something like that. So if I leave my kids the whole thing, they get 11.2 off the top tax-free, but then they're going to have to pay 40% taxes on the 9 million, or my estate will, unless I decide, you know what, I'm going to leave that extra amount, that 9 million, to charity. I'm going to get an unlimited charitable deduction, so there'll be absolutely no estate taxes when I die. And in the meantime, I'm going to buy a $9 million life insurance policy. I'm going to set it up in a separate trust, an irrevocable life insurance trust. My kids will be the beneficiaries of that $9 million. And because it's life insurance, maybe I've paid 50 cents on the dollar, maybe I've paid 40 cents on the dollar, but either way, you know, I've paid for that over time. And that 9 million will go to my kids free of estate taxes because it's a life insurance policy set up outside of my estate in an irrevocable trust, right? Goes to my kids. We call that a wealth replacement trust, by the way. And then the 9 million out of my original 20 goes to charity free of estate taxes, and the 11.2 goes to my kids free of estate taxes. So I just got 20 million to my kids free of estate taxes and 9 million to the charity of my choice free of estate taxes. What did I just do? I engaged in voluntary philanthropy rather than involuntary philanthropy, right? Because if my 9 million got taxed by the government, that's involuntary philanthropy. I have no control over what the government spends it on.
That's right.
Right? But if I choose to the way I just described it, I've benefited a charity of my choice, and my passion is food insecurity. So I would probably benefit, making sure people ate healthy food. I've gotten charity 9 million, I've gotten my kids 20 million, and the government's gotten nothing. That's a win-win for a big estate that's taxable. So your question, that was a long answer to your question about the taxes, but whether or not estate taxes get paid totally depend on how much you die with and how you've set your estate up. And we can set it up to take advantage of all those things I just discussed through various trusts or will in conjunction with trusts or whatnot. This is why this is not a do-it-yourself at home thing. If you have over $11 million, you must go to an estate planning attorney who knows what the hell they're talking about.
Well, I think most of us here are pretty safe about the $11 million limit. I don't know,
let me just get
Brian Maddox might not be, but.
Well, one other thing I do want to say about that is that, you know, a lot of people think estate planning is just tax planning, and it's so much more. It's making sure that your beneficiaries get the assets in a way you anticipate, that if you have, you know, multiple, you know, kids from different marriages, or if you have disabled beneficiaries, you're not accidentally disqualifying them for Medicaid. You know, there are many reasons to do an estate plan besides taxes.
Right. Mary, are you still doing those? I know you're retired. So
no, I'm not practicing law at all. So that means I'm not drafting documents. What I am doing is consulting. So I wasn't joking about the consulting.
Yeah.
So I'm working with real estate investors who want someone to look at their whole situation and help them draw a roadmap to what they need to do to get their goals accomplished. And that can be everything from how do we design an estate plan, to how you set up your entities and how they all talk to each other, and are your beneficiary forms correct, and are your LLCs set up correct, and do you have the right operating agreements, and blah, blah, blah. It's not legal advice, because I can't say that since I'm not practicing. It's consulting, and then I draft basically a bullet pointed memo that they can then take to their attorney that says, okay, I need A, B, C, D, and E. These are the terms. You know, I help them design the roadmap, but somebody else does the work.
That's awesome. That's awesome.
Fun.
I know that's awesome. So a couple of things. I'm going to go back just a little bit. One of the things you said in the very beginning, you talked about how you can use a trust to protect your minor children's interests, your children's interests. So as a lender, when we're accepting other people's money to lend out and they want to use their kids' self-directed IRAs, what we do, even their college stuff, what we do is we put that into a trust, and then the trust is actually the lender. Because if they don't pay, we have to take the house back. Now your minor child is owner of a house, and you can't sell property unless you're 18 years old in the state of North Carolina.
Your minor child is not the owner. The minor child's IRA is the owner.
Right.
And an IRA is a trust. An IRA is a trust.
So the IRA can sign.
Right. Yeah. The custodian signs.
Beautiful.
It doesn't matter. It could be a 6-month-old infant. It doesn't matter. It's not the child that's taking the house back. It's the IRA that's taking the house back. And the custodian is the one who does all that signing anyway. So you're putting an extra layer in there you might not need. Now, if you're taking, say one family has 6 children and they want all 6 IRAs involved, then it makes sense to
do a trust.
commingle all those IRAs and say a land trust, because land trust / personal property trust, because that's ease of administration. You don't now have 6 lenders with 6 IRAs. You've got one lender, the trust, and that trust has 6 beneficiaries that are the IRAs. So it's an ease of administration thing. It's not about taking the house back. That's not the problem. It's the administration thing.
And then in the trust, you can, when you're naming a beneficiary in the trust, if you do, that's when you do the division of 36%, 22%, you know, whatever percent ownership, right? Right.
Whatever pro rata ownership is, sure. So for instance, I have 3 kids, and they inherited some money and I manage that money for them, and I do mostly lending with their money. So rather than have, every time I did a loan, you know, I had Will, Chad, and Jack as the lenders. That would be a pain in the rear end with me as their power of attorney. I set up a personal property trust, named all 3 of them the beneficiaries equally. And now the lender is the property trust, the personal property trust, with me as the trustee. They don't even know what I'm doing. They don't even know they know they exist. They don't know how much is in there. They don't know what I'm doing with it. They just trust me. And they're all in their 20s. I mean, they're not minor children. But they're like, yeah, Mom, you just do what you need to do. They don't even care. So I just go through and I'm like, I'll say to them occasionally, made you guys $5,000 today. You know, made you $15,000 this month. Better thank me. Better remember when I need to go to the nursing home, who's been making money. You know, but Anyway, but I did that for ease of administration, because then I can go to the bank and set up a bank account in the name of the trust with me as a trustee, and I just do everything, and these kids don't even know what I'm doing, right? But they're beneficiaries. So, you know, and they're alternate trustees in there. So something happens to me, another trustee comes in. And if at some point, you know, they need the money, we just distribute all the money out to them and disband that trust. Just get rid of that trust.
That's awesome.
And
So
I've done
Hey,
it
Wendy,
where,
it's Tim Maloney. Can I ask a question of Mary at an appropriate time?
you can do it now. Go,
Yeah.
Hey,
Tim.
Mary. Hey, Mary, it's Tim Maloney, and I'm on my treadmill work desk. So if I'm huffing and puffing, that's what you're hearing.
We want to see a
Nice.
video of that, Tim.
I don't know if I can do that, but it's a great way to get your exercise and tune in and learn something. Hey, Mary, in two questions. In the example you just gave, where you're the trustee for your kids, I just want to confirm that they inherited money that's not in any kind of IRA or Roth IRA, correct? Otherwise,
that's true. Yeah, that's true. If this was their IRA money, I would not be the trustee. Yeah, because
Right.
I'd be
I
a
just-
disqualified party. Yeah, good
Very
point to
good.
make. Yes, this is totally outside of any IRA vehicle. Yeah.
Second question, and I feel sure I know this answer, but I want to confirm it with you. You're using a personal property trust to make the loans for your kids, right?
Yes.
Can a personal property trust own both personal property and real property?
So Tim, you have segued into my next section. So
Okay.
So here's what I wanted to say. This was literally the next point I was going to make. I always hear people talk about a land trust versus a personal property trust, as if they're different things. And people sometimes do them differently. And that's a problem in my mind. And Quincy agrees with me, Wendy, by the way. So what would happen is people would set up a land trust, and they would authorize the trustee to own real property. And maybe they're going to make a loan. They'd set up a personal property trust. They'd authorize the trustee to own personal property. Notes, for instance, right? What happens, and Wendy, we'll go back to your example, what happens when that trust has to take back real property, but the trustee is only authorized to own personal property? Oops, you just messed up. The trustee cannot foreclose because they don't have the power to own real property. So what I do is I created for myself one hybrid document that's just a revocable trust. It's like a land trust, set up the same way, land trust, personal property trust, but I authorize my trustee to own anything that's not prohibited. So, you know, by law or something. So that way, it doesn't matter. I set it up so that same trust document can be used for real property or personal property. If I want to keep it straight in my head what the purpose of that trust was for, I give it a name in the title. The 123 Main Street Land Trust. My kids' lending trust is the WNC for Western North Carolina, WNC Children's Trust. And by the way, I've had versions Roman number 1, 2, and 3, depending on if I came in as a lender or somebody else or something else. So anyway, I don't know if that answers the question.
Well, let me unmute him real quick. Unmute. Just for some reason.
Ask Tim to unmute.
Tim,
himself.
there he goes.
Can you hear me?
Yes.
Can you hear me? Walter has a document that he titles personal property trust, but in the language it says that the trustee can own both real and personal property.
Right.
That's okay,
And
right?
Yeah, absolutely. That's the way to do it. That's the way I do it. And I think that people who do them separately, a land trust versus a personal property trust, are making a mistake.
Thank you.
Yeah.
That's awesome. So anything else, Tim?
No, I'm good for now. she'll trigger some more questions as she keeps talking, which is great. Thanks so much for doing this, Mary.
Oh, sure, Tim. Let me go back through some other benefits of the land trust. It's great. I love answering questions and going off down the rabbit holes, but I want to make sure you get all the information. So one of the benefits of the land trust that I like is that the beneficial interest, what the interest you own as a beneficiary, is not real property, even though the trust owns it, right? So if a judgment attaches, if you have a judgment against you, you know how in some states a judgment against you will attach to any real property you own?
Mm-hmm.
Well, a beneficial interest is not real property. So if you have a judgment against you, it should not attach against the trust, especially because you should have your LLC or another trust as the beneficiary of the land trust. But it doesn't, if I own a property in my own name and a judgment was against me, it might automatically attach to any real property I own. But if I own it in a land trust and my LLC is the beneficiary, then a personal judgment against me will not attach to that property in the trust. Does that make sense? And we talked about how the trust usually forbids anybody from disclosing the terms of the trust. So that helps for the anonymity, right? Another benefit is that there's no way to seek partition. You guys know what partition is in real property, right? So if Wendy and Tim and I all owned a piece of property as tenants in common, and I wanted my share out and they didn't want to buy me out, I could go to court and ask for partition, which says that the court would order that property be put up for sale, and third party buys it, or they could buy me out, but it would force their hand. And if we all own the real property on the deed. If we own the beneficial interests of a land trust together, there's no way to seek partition. So one beneficiary cannot force the other two to sell unless the terms of the trust say that. You can't go to court and force a sale, if that makes sense. So that's a big benefit that people don't think about, because people aren't thinking about if you have multiple beneficiaries all on the same deed, that one person can go force the sale of the property in court. Okay. So we talked about being able to avoid probate. That's another benefit. If you have multiple beneficiaries, you can do a beneficiary agreement between everybody that sets out the rights and obligations of those beneficiaries and how they all relate to each other within this trust, just like an operating agreement for an LLC, right? Or a joint venture agreement or anything else. There's no state filing for a trust, so there's nothing the trust is not filed anywhere on the public record. There is no state filing fee, no registered agent, no annual fee. So those things are all make it easier to deal with. So if you've got 100 properties and you want each one in a separate land trust, it's really simple. You create one template document and change the title and the legal description of the real property 100 times. Maybe change the trustee a few times in there. It's super easy to duplicate your efforts. Whereas if you're doing a separate LLC for every property and you've got to go set up 100 LLCs and pay 100 filing fees and 100 annual fees and file 100 annual reports, what a pain. But, nobody would do that. And I want to say, Wendy, let's jump into why I have not bought anything in trust so far. I have several reasons for that. One is that for the most part, when I started acquiring properties, I wasn't really that familiar with land trusts, wasn't dealing with them at the time. That's one reason. So I used LLCs because I was a lawyer who didn't do land trust at that time, and that's what I was familiar with. So that's the first issue. The second issue is that a lot of times different properties, I had different other partners, so to speak. And I wanted to make sure that so maybe I own property with my brother and sister, or own property with one business partner over here, or property with another business partner. And I wanted the limited liability of a limited liability company. I didn't want to be responsible in any way, shape, or form for something my other business partners did or didn't do. So an LLC is a state mandated creditor protection like that. A trust is a little iffier on that. I didn't want joint ventures. I just wanted it clear under state law. The other reason is that a lot of these properties had super high equity. So if I did it in a land trust, the equity in those trusts would be subject to judgment and could be taken away because remember, a land trust is not a state mandated creditor protection vehicle, right? And we'll talk about that in a minute, how LLCs
Even
are.
if it's owned by another trust, which is owned by an LLC?
Well, remember, that protects, if a judgment gets against you, it protects the between the trust and you, that's the protection. But if that trust owns a rental home and somebody sues the trust because they slipped and fell on that rental home and they get a judgment against the trust, they're going to get that house, equity in it. There's no creditor protection for that.
Okay.
They're going to get it. Right? The creditor protection at all is setting it up. So if you put an LLC as an ultimate beneficiary, if you have the car wreck and get a judgment against you personally, it can't bust through that line between the LLC and the trust to get to the trust assets. Or if the trust has a judgment against it, it can't bust through the LLC line to get to your personal assets. A land trust does not protect the equity of the property owned in land trust. So a lot of people who are buying highly leveraged properties, maybe they got 10,000, 20,000 equity in a property, they're willing to risk it. They do one land trust per property. They've only got $20,000 at stake in any one land trust. My land trust, I had one building in LLC that's got $800,000 equity. I want a state mandated creditor wall for that property because I have huge equity at stake in that property. Does that make sense?
Yeah. Yeah.
So that was one of the main reasons that I wanted the absolute creditor protection available to me under state law. And a land trust does not give it, period.
Gotcha.
Doesn't. Now, if I were out there with a Walter model or somebody else where I'm doing hundreds of transactions, I'm mostly a buy and hold big asset girl. But if I were out there buying and selling and lots of partners and changing and doing all this, and it was in and out and in and out and in and out, I would absolutely use land trusts for their ease of administration and their flexibility, the ability to take property back without foreclosure. That's a big potentially, not guaranteed. There are a lot of reasons that I might do it if I were more of a mover and a shaker, but I'm not. I'm a buy and a sit person usually.
Gotcha.
The reason I like these trusts for loans is because loans are different. I am in and out of loans, 6 months, 9 months, a year. You know, I want it to be easy. But if it's my money, like if it's my IRA, I just have my IRA be the lender. I'm not setting up a trust or an LLC. Because there's not much liability as the lender. If I'm just lending my own personal money outside of an IRA, I just lend it out of my revocable living trust or my name. I don't care because there's not much liability. You don't sue the bank when somebody slips and falls in the house you have a mortgage on. The bank has a mortgage on, right?
Right.
But if I'm trying to amalgamate interests like my kids, or if I were to bring a group of friends together or a group of other IRAs together, then I would do it through some sort of personal property / land trust hybrid because it's for the ease of administration, not the creditor protection. I was more interested in Mac Daddy creditor protection than I was anonymity or ease of administration. So that's why there's no one size fits all. People ask me all the time in conferences, well, should I do this? I don't know. It depends. There's a million different factors. I mean, people get tired of hearing lawyers say it depends, but it really does depend. And I usually can't answer a question in a presentation about anybody's particular situation because I need an hour to sit down and find out what their situation is and what their goals are and how they're structuring this. And you know what I mean?
Absolutely.
So, no black or white answer to that.
Well, one of the things, oh shoot, I forgot you talked about not having to file any of these trusts with the state unless you have to have a bank account in the trust's name, because banks, our banks would not allow us to have a bank account without having documents from the state. We did a certification of the trust. We turned that in.
You need a different bank. That's ridiculous.
Okay.
That's ridiculous. They can't tell you that you can't have a bank account in the name of a trust. It's done all over the world constantly. Are you using a tiny, small regional bank that just doesn't know anything outside the neighborhood?
Well, it might be, but they're good to us. They give us money when we ask.
Well, they're good to you, but they're not going to let you use a trust. That's ridiculous.
Well, they're letting us use it. Yeah, they're letting us use it, but I ended up having to set the trust up with an EIN number.
Well, that's fine. That's not recording it anywhere. You can still have an EIN. All that does is say who the grantor, trustee, and the address is. But nobody can go get that document, that SS4 document from the IRS without a subpoena in a court of law.
Gotcha.
That's private. The IRS doesn't disclose to anybody else what is on that SS4 document.
Gotcha.
I get an EIN for everything for banking purposes, if nothing else. I fill out that SS4, and if they check reason for applying, I go banking purposes.
Right. Well, and you probably remember me texting you as I was filling out my forms, which one should I choose? I know I was driving you nuts on that. But and looking at that, I was shocked to see how many different options of a trust that there are out there. And and you choose one, and then there's several that if this, then all of these.
Yeah, but if you're doing it for the EIN, to get an EIN, really all they want to know is it an irrevocable trust or a revocable trust.
Right.
They don't care. That's all they care about, because is it included in your tax? Are you taxed on it, or is the trust taxable? That's all they want to know. Irrevocable, revocable.
Okay.
And the reason for that is if I'm setting up a revocable trust, then let's say my living trust, my estate planning trust, that's what we call a grantor trust, and it is ignored for tax purposes. And it looks through the trust. IRS looks through the trust to me as the grantor, and everything goes on my personal tax return. If, however, I set up an irrevocable trust, it has to have its own separate EIN because it's a separate legal entity. It's not ignored for tax purposes. It has to file its own tax return. And whether or not the trust pays the taxes or the beneficiary pays the taxes depends on how it's set up and whether the income is distributed out to the beneficiary. But the reason the IRS wants to know revocable versus irrevocable is they want to know, should I expect a tax return from an irrevocable trust?
Gotcha.
Or are we going to ignore this and just look to the beneficiary?
Gotcha.
See? So you don't have to go through, well, this is an irrevocable, IDGT, CRT. You don't have to tell them the actual specific type of trust. You don't have to say it's a land trust or personal property trust or an estate planning trust. You just say revocable or irrevocable.
Right. And I'm sure we set it up as a revocable trust.
Yeah. Now, that's a good point to bring up, because I cannot tell you how many times I've seen lawyers who don't understand land trust. Client goes to the lawyer, says, I want to set up a land trust for asset protection. And they might bring in one of Walter's templates or something else. And I have seen this happen, not with Walter's document that I know of, but somebody brought a land trust template to a well-meaning attorney, real estate attorney, and said, I need this to be for creditor protection. What did that attorney do? They changed the whole trust and made it irrevocable, was one of the things they changed. Why would they do that? Because they're traditional attorneys that say, well, a creditor protection trust is an irrevocable trust, which is exactly right. But the real estate investor throws around the terms like creditor protection trust because they don't really understand. This is not creditor protection trust. You may be using it as a smokescreen and hope to avoid creditors, but legally it is not a creditor protection trust. Only an irrevocable trust is a creditor protection trust. You see what I mean?
Absolutely.
So lawyers who don't, there's a miscommunication between a client and a lawyer because the client doesn't understand what they're saying. The lawyer's trying to infer what the client is saying, and they get it wrong all the time. So they think they have a land trust when really they have some irrevocable trust they can never change or take the assets back out of. So look very carefully at your trust documents.
Gotcha. Okay, we're gonna do one more question, and it's from Leah Coleman. Leah, if you'll unmute yourself, I'm gonna let you ask that question. And then Mary, I want you to tell people how they can get in touch with you to be their consultant on that. Leah, are you unmuted? Yep, you are.
Yes. Hi, ladies. Hey, Mary.
Hey, Leah, how are you?
Good. Sounds like a really basic question that I feel like I already know the answer to, but I just feel like it would be a good reconfirmation that I do know the answer. So I want to ask. So I have a property, in an LLC, getting refinanced out of a renovation loan to a longer term loan. And this week, the lien holder just asked me to sign a personal guarantee if I'd be willing to during the refi. So my question to you is, would it benefit me to set up a trust to protect myself personally any further, or should I let them know or remind them that their money's protected via the homeowner's insurance and being on the deed as the lien holder in first position? Because I guess just listening to you this morning, it really got me thinking about the layers of protection while I'm building up more assets and growing.
No, that makes sense. Let me ask you a question. Is this a bank or an individual private lender?
This is a really good question. So it is an IRA. They're lending from their IRA. So I want them to be protected. And we're very open with our communication. And I do want to make sure we do the right thing. But I'm also, wanting to make sure I protect myself because we have other businesses and I just don't want to put any other risk in there.
So this is a complex question to a degree. Let me say a couple things. If it was a bank, you would have no choice but to sign their personal guarantee. They're not going to make you a loan without one. Many private lenders are not going to make you a loan without a personal guarantee. And that's their choice. I always ask for a personal guarantee. The only time I've ever done it without a personal guarantee, you can't have a personal guarantee on an IRA, by the way. They couldn't personally guarantee a loan their IRA took. Different than your situation. But anyway, you know, I as a lender will ask for a personal guarantee. The only time I haven't is if it's been a borrower that I've worked with a lot and I trust them and their integrity. Now, let's go into your specific questions. If you sign a personal guarantee, a trust is not going to protect you unless you set up an irrevocable trust and you transfer every single asset you have into it, into the irrevocable trust, which means you can never get that property back. You can't control it and you can't use it. So that's unworkable. That's unworkable. You're not going to do that, right? So that wouldn't work. Now, you said, are they protected via the homeowner's insurance or being on the deed? Two problems with that. Homeowner's insurance only protects them if the problem is that the house burns down or something happens, right? Homeowner's insurance doesn't pay if you just stop paying, right? So homeowner's insurance will not protect them for a non-paying borrower, number one. And number two, they're not on the deed. They don't own the property. They have maybe, and I don't know in Virginia if you're deed of trust or mortgage state, I can't remember, but they're like a bank. They have a collateral interest in the property, but they're not on the deed.
Yeah, I'm sorry, I might have misstated that. Thank you.
So the deed, if it's a deed of trust, for instance, which a lot of people confuse a deed and a deed of trust. The deed of trust is the document that says the property is collateral for the loan. So let's say they're in first lien position, that deed of trust protects them. If you stop paying, then they can foreclose on that deed of trust. And if the property is worth what the loan is, then, you know, they're going to get their money. However, what happens if, you know, they've loaned you the purchase price plus the renovation price and you stop paying when it's still a shell? That property is now not worth what they loaned yet. Potentially, depending on the loan to value and all that kind of thing. So they might say, well, even if I take it back, and Leah has absconded with all this money, I've now got to chase her for the money, or I've got to fix up the house myself and blah, blah, blah. They might not want to do that. They might want to say, look, I don't want just taking the house back to be my only recourse. I want to be able to go after you personally. Now, I will also say that when I ask for a personal guarantee, I'm probably not anticipating ever going after anybody personally if I have done my due diligence on the property well. But what a personal guarantee does in my mind is it lets the borrower know that I'm dead serious about their requirement to repay. And I think, if they know their personal assets are on the line, they're going to take my interest as a lender a little more seriously. Right? They're not going to say, well, I don't care about this house. I'm just going to walk away from the house. Didn't go the way I wanted. Forget it. You know, bad people will walk away and leave a lender hanging. I want somebody to know, no, you can't just walk away and leave the house to me. You know, if I need something more, I'm not going to let you just walk away with my money. So that's why most people will ask for a personal guarantee. And I usually ask for one. And I have turned down loans if somebody's not willing to give me one. Because of this way, if you know what you're doing and you have the full intention to repay, why wouldn't you sign a personal guarantee? I would. And I have many times.
Absolutely.
If I take other people's money, my first responsibility is to make sure those people get their hard-earned money back. Their interest is ahead of mine every single time. So if I screw up because I either don't evaluate the property correctly or I don't do my job right, why should they lose? They did their job. They loaned the money. So to me, I don't have a philosophical problem with personal guarantees. I've signed them and I've asked for them. That's a long answer, so I apologize for that.
No, that's really good because there's, there's a lot in our culture right now that are having problems with stuff right now in this climate. And that's another reason why I just wanted to ask about the layers of protection that I can give the lender. And so I see what you're saying. Of course, for me in this particular scenario, I would likely be more inclined to refi them out, and pay them off or either sell the property before I would ever feel, like I would want them coming after me. So I do feel like that would be like the third thing. I mean, we work well together, so it's good. I just was thinking, we definitely are used to banks asking for questions like that. And this being an IRA, I wasn't sure like how the parameters and, you know, should I still put a trust? Should I still put the property in a trust? You know, since we're on the topic of that.
I'm not saying the property shouldn't go in a trust. That's a whole different thing. And we're going to get into the weeds on this. But,
Yeah.
but to answer your
I will keep
specific
you.
question, if you sign a personal guarantee, a revocable trust is not going to protect you from having to follow through on a personal guarantee. Let me, I see that Tim Maloney was answering, there's something about community property state. Tim, you said, do you require the spouse of your borrower to sign the personal guarantee? And Wendy said, it depends on if your state is community property state. And Tim said it's not. Now, I want to say one other thing. North Carolina, for instance, is not a community property state per se. However, it does give a spouse the rights in real estate. So in North Carolina, even though it's not a community property state, you better have the spouse sign everything, or you don't have the full protection, because the spouse has interests in a property. I could, if my assets in North Carolina, if I own them in my name, I could not encumber that property without Frank's signature. I can't lease it without Frank's signature. I couldn't sell it without Frank joining in on it, even though the deed is just in my name, because North Carolina gives marital rights in real property. So that's not a black or white answer about whether it's a community property state. You got to know your specific state's laws. It's not just community property.
Mary, I was trying to practice being an attorney, and I guess that didn't work out too well.
I mean, it's a partially good answer.
Thank
You certainly
it
have
depends,
to.
is what it
Right, it depends. You certainly have to have a spouse sign in a community property state, but it's not only a community property state.
That's,
See what I
that's
mean?
Hey, Mary,
yes.
hey, Mary, it's Tim.
Hey, Tim.
Follow-up question to that. So, you know, let's say I make a loan to someone, to a borrower who's married, and I only have the borrower sign the personal guarantee. And let's say he and his spouse own a joint tenant with right of survivorship personal home. If I wanted to go after that, he would be able to transfer, the borrower would be able to transfer his interest to his spouse such that he owned nothing, correct? Such that I would have nothing to go after unless I had the spouse also sign the personal guarantee.
Well, it depends, Tim. It depends answer. So, all right. And I'm going to base this off North Carolina law where I practiced, because that's the law I know. So you have to check it in your state. In North Carolina, if a husband and wife own real property in that state, unless they do something otherwise, it is owned by something called tenancy by the entirety. What that means is, as long as the husband and wife own that property together, if you have a judgment just against one spouse, you cannot go after that property. If, however, two people own something as joint tenants with rights of survivorship, which is a different way to own property, you could go after the borrowing spouse's half, but you couldn't go against the spouse's half because the spouse was not a borrower. Now, you said the spouse could just, the borrower could transfer to the spouse. If the borrower transferred to the spouse in anticipation of you suing, then that would be a fraudulent transfer, and you could get the court to set that aside because they were doing it for the purpose of delaying, hindering, or defrauding a creditor. Not allowed. See what I mean?
Thank you. Yes, thanks. I've never had to do it, but I just kind of think I had.
The safest thing is if you have a married borrower, have the spouse at least sign off on it. Even if the one spouse is the borrower, the other spouse should at least sign a consent to it. We call it it could be a non-owning borrower. If the spouse is on the deed, then you better have both of them sign as borrowers, period. If the spouse is not on the deed, I still have the spouse sign as a non-owning borrower, basically.
Thank you.
They don't own the property, but they're consenting to the encumbrance against the property on the chance they would have a marital interest in it. That may be overkill in other states, but that's how we would have to do it in North Carolina.
Thanks. That's very helpful. Appreciate it.
Yeah.
Awesome. So Mary, we're almost 30 minutes over.
Oh, oops. Sorry. I told you.
Listen, nobody's leaving. That's what's so funny.
Well, I'm happy to sit here and answer whatever questions you guys have.
Well, here's an option. So next week, next Friday, Walter Walford is coming back. He was here last week, and we're bringing him back. Our intention was to talk a little bit about short-term vacation rentals next week, but if you would be willing, we'd love to have you back next Friday, and you and Walter talk about the trusts and the documents, and you shoot holes in Walter's documents.
Yeah, Walter and I don't always see eye to eye on our trust issues. We've been on many panels together. It's very funny, actually. Walter, Quincy, and me. It's very funny to watch.
It is, and I'll even reach out to Quincy and see if he'll join us too. Is your calendar open next Friday?
Let me look. I mean, I'm in quarantine, so it's pretty much open every damn day.
We're open in South Carolina. Got my nails done yesterday. Woohoo!
Well, I am finally going to get a haircut on Monday. It's been like 3 months. I've shrunk it down with product as much as I can. As far as I know, I'm available. Just reach out to me again. I don't think I have anything specific.
Awesome. And with the pictures that I see of people, heads nodding yes or no, would you be interested in continuing learning more about trusts and documents and how they work? Everybody's going, yeah. So I really am going to have to cut it off right now because I have another thing that I have to go do, and since I'm the host, I have to do that.
Yeah. Somebody asked for my email, Wendy, so I will.
I want you to do all of that. How can people get in touch with you? Because I've had some private people come through saying they want to talk to you about consulting with them.
I just put my email up there, and I'll put my cell phone. I still have my law firm email, but even though it says Mary Hart Law, it's not Mary Hart Law. It's Mary Hart Consultant. I mean, that's the email, but I'm not practicing law.
Okay, so it's Mary Hart at maryhartlaw.com. Her cell phone is 828-231-2583. I also want to make sure everybody understands that if you go down to the bottom of your screen, you'll have a little thing that says chat. You click on chat, and all the chat that's been going on will be over to the right of your screen. Now, over at the bottom of the right-hand side of the chat screen are 3 little dots. And in those 3 little dots, it will say Save Chat. If you save that, you can go back to the chat and get all the information that we've talked about. I've had a lot of people too ask, can I get a recording of this? The answer to that question is yes. I will send out an email through the MailChimp that will give you access to a Dropbox that has all of the recordings that we have since we've started doing this back in March, I guess it's been. So you absolutely can get to that. If you're not getting my reminders every Friday or every Thursday afternoon telling you about this group, you can email me, Wendy at carolinahardmoney.com. I will add you to that list. We have 620 people that are on our list for Sonrisers, people who have been and want to constantly get reminded. Mary, you have just proven why I say you're the smartest chick I know.
Well, you're very sweet. Thank you.
And that's just the tip of the iceberg. You're awesome. You're awesome. So thank you so much for sharing everything that you have shared. I'm very, very grateful. And I know everybody here is as well. So she has committed to next week. Y'all heard it here. We have witnesses. And we'll do this again. So don't miss it, folks. Thank you again, Mary.
7:30 is early for me. So I'm always really Wendy. I am not a morning person.
I know. but your brain starts working right away.
Well, that may be true. Right, thank you. Thanks, everybody.
Thank you. We'll talk to you next week.
All righty. Bye.
Have a good one.
Sure.